Oh yeah, yeah. The only thing is, if you want to highlight, you need to say that the text and then do it there. You need to do it directly. If you, oh yeah, that's great. I mean, if I so if you want to save it, you need to do it next time and then do that. And then it keeps it.
Okay. Right, good afternoon everyone. Sorry we're a little late starting. Welcome you all back and to a good 2015. Hope you've all had a good Christmas and Happy New Year. And we're obviously going to have some challenges in the year ahead. But I think this is the first main meeting of the new year, especially for planning. So welcome to you all, applicants and members. Could you please all make sure your mobile phones are switched off before we start? Obviously, a lot of you have forgotten already. Right, I'm County Councillor Ruth Edwards, your Chair of the Planning Committee, and I'll now ask all those on the top here to introduce themselves. To my right,
Peter Clark, I'm the Vice Chairman.
Robert Tranter, Head Legal Services and Temporary Monitoring Officer.
I'm Philip Thomas, I'm Development Control Manager.
Paula Clark, Planning Control Manager.
Richard Williams, Democratic Services Officer.
George Ashworth, Head of Planning.
Martin Davis, Development Plans Manager.
right, thank you all very much. We'll now start with the first thing on the agenda, apologies for absence. I will in a minute. Apologies for absence first, please.
I receive no apologies, Chair.
Okay, Councillor Howarth.
Councillor Taylor will be with us. She's just been held up for 5 minutes.
Right, thank you very much. Declarations of interest? I will take them now in the beginning of the meeting, if I could, please. Also, after they've taken their declarations of interest, I shall now move we've only got 2 applications for committee today, so I shall move those now to the next item after I've done the accuracy of the minutes, so that the members of the public that are here will not have to wait through a long presentation of reports, if that's all agreeable with the committee. Okay? Right, the 2 declarations of interest now, please.
Yes, Madam Chairman, I wish to declare on 00510 personal and prejudicial.
Right, thank you both very much. Right, first application. Oh, I'll do the minutes then now, first of all. Right, we now go to item 3 on the agenda. Yes, but right, page 1. Page 2. Page 3. Page 4. Page 5. Page 6. That was the minutes of the Planning Committee on the 2nd of December. You've proposed move. Could you have a seconder, please? Thank you. Or a show of hands if you're all in agreement. Thank you. Would you prefer that Jim does his tree preservation, or should we take the applications first? Is it a very long presentation, Mr. Lee? Right. Would you like to do yours now then, Jim, and then you can leave and carry on with your work? Thank you.
I don't know if you can see that. For those of you who don't know me, I'm Jim Keach, the tree officer. I'll keep this as brief as I can. You should have all received the copy of the report, which is requesting that the Planning Committee confirm without modification tree preservation order number 248/A1. Just briefly, the reasons for making this order was the former paper mill site at Sudbrook is allocated for residential development under the Monmouthshire Local Development Plan. A planning application came in on the 31st of March from Harrow Estates to demolish the existing buildings on the site. As part of that demolition work, all vegetation, including all trees, was also to be cleared. Included in the planning application was a bat emergence survey dated October 2013. Members may not know, but I'll confirm it for them, that all bat species in the UK are protected under European legislation. The Council's Landscape Officer was satisfied that the level of information contained within the bat emergence survey was enough to consider protected species in association with the demolition of these buildings, as long as no trees were removed during the scheme. That was the important part. Trees previously identified as having bat roost potential are to be re-inspected and categorised in accordance with Bat Conservation Trust guidelines. We had one objection to the TPO, which was from Harrow Estates PLC, the applicants. I would draw members' attention to point 4 in their objection notice, which stated that during the previous application on the site in 2012, my counterpart at the time, George Weston, didn't consider that trees at the site to be worth retention with a tree preservation order. Please note that these comments were given in isolation and in respect to landscape value only. Biodiversity issues were not considered at the time. The Council's letter of response to the objection letter is also appended to this report. I'll take any questions now, Madam Chair, if anybody would like to.
Thank you very much, Jim. Anybody wish to, especially the local member, which I think it's in the ward of Councillor Fox, but a neighbouring councillor, if anybody wishes to speak. Councillor Watts.
I'm an experienced member, Chair, thank you. I don't like to see any trees being... Sorry. I don't like to see any trees being cut back for the sake of cutting trees back. If it's essential, yes, but the birds and animals and that need those trees as well as houses. Thank you.
Thank you, Councillor Watts. Anyone else wish to comment? Councillor Jim Higginson and then Councillor Blakeborough.
Thank you, Madam Chairman. I mean, my ward is adjacent to the Portskewett ward as well, and as far as that goes, I mean, if there's a tree that needs protecting, and I appreciate the comments that the officer made in relation to bats and the rest of it, and you know, it was his recommendations are not done without some due consideration for everything around there. And from that side of it, I think you know that there are certain trees that need preservation.
Thank you, Councillor Higginson. Councillor Blakeborough, please.
Just a quick question, really, just to clarify for me, because in terms of protecting the trees, it's not all of the trees, but just certain trees.
No,
is that right? It's
site.
every single tree on that
was the whole
site.
point of it. We could only put an area tree preservation order on because we didn't have proper access to the site. As you can imagine, it's a big old site now, an old factory that's now redundant, so it's all locked up and secured. We would have had to get access from somebody up north, I think it was up in the north of the country, to get us access onto the site. We're not quite sure whether they would be quite willing to do that. So we put the area tree preservation order on initially, which just held the site and protected every tree on there until such time as all these other matters, biodiversity issues, etc., have been fully considered. And then if there are any trees that need to come out in order to fulfil the planning permission they may get, then that's fine. That will override the TPO. But it was purely just to hold the site for the moment.
So this is just temporary, so till you've got... I'm just aware that there's probably some trees that aren't worth protecting.
Indeed.
But this is just the first point, really.
This is just it, just to prevent the wholesale felling of everything. Yeah. There will certainly be trees that will have to be removed as part of any development on that site, definitely.
Thank you for that, Jim. Councillor Roger Harris.
Thank you, Madam Chair. Jim's just answered my question, and it's obviously a holding exercise to make sure that any protected species there are looked after properly, and if trees aren't worth preserving. But just diverting a little bit, if there are some trees worth preserving, then I presume you will lobby hard to make sure that they stay.
Yes, we will try and ensure that they are incorporated into the design. I think that is the intention of the applicant, is to retain as many of the more desirable trees as they can. But there will also be in place a robust landscaping scheme thereafter, which will have to have approval as well. So we'll ensure that more trees are certainly planted. Yeah.
Thank you, Madam Chair.
Councillor Howarth and then Councillor Murphy. Thank you.
Chairman, may I just ask, putting a TPO on the site then to protect the site till the initial stages of the application are with us and we have all the surveys done, does this last for a certain length of time? How long is it for? 12 months or for until?
Initially it was for 6 months, and it should have been confirmed on the 3rd of December last year. Unfortunately, due to pressure on the agenda for the last meeting, they weren't able to put that confirmation report on. So I've had to inform the applicants, or the objectors rather, that as of the 4th of December last year, the trees would remain unprotected unless and until they were the tree preservation order was confirmed today. So thankfully they haven't cut anything down in the meantime. I don't think it would be in their best interest to do so. But yeah, if the tree preservation order is confirmed today, which I hope it will be, then it will last until the trees die or planning considerations overtake.
Thank you, Jim. Councillor Murphy.
Yes, thank you, Chair. I just seeking just a little bit of clarification. You more or less answered this, Jim, but you said that inevitably some of the trees will go.
Yes.
Have we identified those that are definitely not likely to go? I'm thinking in terms of when the applicant submits a more detailed scheme.
Yeah.
If we've already identified those that are not coming out under any circumstances, it's going to make life a lot easier for Harrow Estates to come up with a sensible plan rather than it being knocked back.
Yeah, I believe they have now submitted a planning application. It hasn't been validated yet, which is why I haven't had a chance to comment on it, but I'll certainly look at those issues.
Because I think that would help. That would help a lot, and would make some sense to the TPO.
Yeah. Thank you very much. Anybody else wish to comment? Councillor Higginson?
Yeah, I'm prepared to bear in mind this confirmation of a provisional tree preservation order. I'm prepared to move the recommendation, Madam Chairman.
Thank you. Do you have a second? Thank you. Show of hands for approval.
That's unanimous, Chairman.
Thank you very much indeed. Right, now we go into Councillor Taylor just joined us, so now we're going to do the two applications on the agenda tomorrow. Right, first one then, Phil, this is Vanessa.
Chairman, before the application starts, if I could just clarify something. Both Councillors Clark and Councillor Strong have declared personal and prejudicial interests in respect of this application. In respect of Councillor Strong, I understand that's in respect of his son's business. Under paragraph 14, subparagraph 2, sorry to be a bit wordy here, of the code, Councillor Strong may make representations to Planning Committee after hearing the presentation from Paula, but at the conclusion of making those representations, you must leave the room, Councillor Strong. Okay, so you can't take part in the vote, but you may make representations. After doing that, I would ask you to leave the auditorium, please.
Would I speak after this lady behind me who wants to speak on this? Do I speak?
Yes, speak as you normally would as the local member when the time comes. But as I say, at the conclusion of whatever you want to say, if you could please leave the meeting. Thank you.
Right, thank you, Paula.
Thank you, Chair. This application seeks permission for the change of use of part of Little Bank 8 Porthiccan Street Esk to a solicitor's office. That's a photograph of the property there. Members visited yesterday. The number of employees is expected to start at 3 and rise to a maximum of 7, excluding cleaners. The property has no access, parking or garden, as it occupies a very constrained site. There are other commercial uses on Porthicahn Street, including a veterinary surgery and a fish and tackle shop. The property was previously a dwelling, although the occupier ran a property surveying and auctioneering business from the property for over 20 years. This application is a resubmission following the withdrawal of a similar application in 2013. Since this time, the applicants have secured the rental of 2 parking spaces within the town centre, and the LDP has been adopted. Objections to the application have been received from the Town Council, Highways and neighbours relating to the lack of parking provision. The property is within the development boundary of Usk. Part of the property will still be used for residential purposes by one of the senior partners, whilst the remainder will be used as a solicitor's office. Although A2 uses are encouraged within central shopping areas, this property is 15 metres outside the area. However, it's still within the development boundary of Usk, and the A2 use is not contrary to any LDP policies. Policy S8, relating to enterprise and economy, supports economic growth, and Policy E3 allows small businesses to operate from home, provided there is no adverse impact on local amenity. The main issue is therefore the lack of any parking provision. There is some roadside parking available across the road, and the applicants rent 2 private spaces on nearby land. Other staff and visitors would park in the town centre, where 3 public car parks provide 286 spaces. The application site is within 180 metres of the car park at Twin Square, 250 metres of the main car park, and 50 metres from on-street parking on Porthicahn Street. These are all well within walking distance. Indeed, the distance from the entrance to County Hall and the bottom of the car park is 200 metres, which puts it in a bit of perspective. It should also be considered that a previous use as a dwelling would have required 3 spaces and a turning area. However, it has no provision. And this further point is that residential occupiers are less likely to be inclined to park away from their premises than employees. Also, the property has no garden, therefore its suitability as a family home is questionable. On balance, although there is an objection from the Highways officer, given the economic benefits of the business, the proximity of the site to the town centre and its car parks, and the extant lawful use of the property as a dwelling, it is not considered reasonable to refuse this application on highway grounds. Officers therefore recommend approval of this application, subject to the condition attached to the report.
Thank you. I believe we have a member of the Town Council wishes to speak. No? Just oh, no, just a member of the public.
A member of the public.
Just a member of the public. I'm sorry, I was looking at something else on there. Thank you. If you'd like to take the stand, please. You have 4 minutes after stating your name, please.
Hello, my name is Alison Wheatman. Can everybody hear me? I think I met many of the councillors at the site meeting yesterday, and you will know that access to Littlebank is via the private drive to my house. And there are double yellow lines on both sides of the road in Porthicahn Street, where the drive goes down to Porthicahn Street. So Littlebank has pedestrian access via our private drive, but no parking space, and the lack of parking has been and remains our major concern. We wrote with these concerns in May 2014, and as has been mentioned, the Highway Agency, us Town Council and a number of neighbours have placed similar objections. I understand that the office now does have 2 parking spaces next door in the Three Salmons overflow car park, but I'm aware that there's a residential planning application in there, so I guess that those will be temporary rather than permanent car parking places. We understand that the rationale for a business there is that a commercial property surveying business was run from the site for 20 years, and that was Vince Keneally, our previous neighbours. We were neighbours to Vince and his wife Pauline for 8 years of that time, and as far as we are aware, Vince, who didn't have any employees, didn't actually, it was his home with Pauline, he didn't actually conduct any business as far as we know from his home. If clients did come to Littlebank to talk to Vince about his business, there were certainly no parking issues such as the ones that we've experienced during the 18 months that the Star Legal business has been operating in Littlebank. Despite the no parking notice, vehicles of visitors have been parking in our private driveway, sometimes blocking our own vehicular access into and out of our premises, and the owner, Richard Vaughan, has been notified on several occasions. Cars and vans have also parked outside on the double yellow lines in Porthicahn Street, causing problems for us and our neighbours opposite in accessing our drive safely and creating a blockage when the road is busy, which it is at some times of day, and I guess that's why there are double yellow lines on the road. We think these issues will get worse. The business runs an active post room from the property, so it's not surprising that delivery vans are pulling into the drive to collect and deliver bags of mail. And as far as we know, although the house is now fully converted into office space, I'm not aware it is a residence, but as far as we know, it's fully converted into office space. The business isn't yet up to its full complement of 6 full-time and 1 part-time members of staff. And the increasing footfall of clients, we imagine, is sure to include those who can't walk a great distance or are calling in for a brief period and are not willing to walk from the car park. We can, and we probably will have to seek permission to put a barrier to prevent vehicle access into our drive, but the effect will then be to increase the burden of parking on the double yellow lines outside, I think, and this will add to the additional burden on our neighbours as well as ourselves. So in summary, there are serious concerns around the business and parking within this business in this location, and thank you for listening to and considering these concerns.
Thank you very much indeed. I believe we now have another speaker for the applicant.
Yes.
Could you also take the stand, please? You have 4 minutes, and could you please state your name when you stand? Thank you.
My name is Jeremy Mead, planning consultant for the applicant. I've listened to Alison Weekman on this, and I can understand in many respects sharing a drive is difficult. Change of that is difficult. But over the benefit we have in this application is over the last 12 to 15 months, we've had an opportunity to see where the problems are and therefore deal with the problems. There are signs at the site, at the driveway, at the entrance, stating strictly no parking as far as the applicant is concerned. And the problems when occurred have been dealt with. And to the record that we have, there have only been 3 emails raising objections or raising a complaint. And 2 of those were to do with cars or vans parking on the double yellow lines. We, of course, cannot control what happens on a double yellow line, and with the current increase in white van deliveries, that's a problem that's arising all over the country. And I don't believe is anything to do with the altered use or the change of use here. The property as it stands is, as the officer reports, is not conducive to actually be residential. It's split into 2. We do have an application pending to alleviate that, but the use of it is now is really at its maximum. Solicitors do not attract large numbers of client visitors. It is all now done on the internet and by post and email. I think even meetings now are not conducted at the offices as they used to be. In fact, the meeting room has been it is really a business that's brought 6, 7 jobs to us. a lot of the complaints about, you know, should it move, should it have taken another one, it was, this property was chosen because it actually, we did all the pre-application inquiries, and there was no real objections to it at that stage. In fact, it was encouraged. The other aspect, and it seems primarily that access is the problem, and that parking was a problem, has been resolved, and has shown not to be a problem over the past 15 months. And, you know, it just shows that if you wait and see, you do actually find that things do work, and change is always difficult. Thank you.
Thank you very much indeed. As you're aware, we visited the site yesterday, so I'll call again on Councillor Strong, and it is in his ward. That is why he is also going to speak. Thank you, Councillor Strong.
Thank you, Madam Chairman. Having heard both submissions, I have great sympathy with Mrs. Wheatman. Obviously, it does affect her more than anyone else. The number of cars, I think that, or a number of occasions that the cars have caused problems, I think was said to be 2 or 3. I believe that it was probably more than that have happened. But it does affect Mrs. Wheatman's family quite a lot. And to rub salt into the wounds, really, she probably would have to put up a barrier across that drive to stop unauthorised parking anyway. There are premises, or there were premises for the last couple of years in Usk. One was a solicitor's office, which possibly would have been more appropriate. They're putting this new business in really what I consider would be an inappropriate area. The offices in the main street would have been possibly better used for this business. It's right near the car park, and a lot of these problems wouldn't have existed. So I think my son, who's renting out 2 spaces in the Three Salmons car park to the solicitor, would probably kill me for speaking the way I am, but it's in my view it's the wrong business in the wrong place, and on highway grounds I would ask the, well, I would not say that, I would ask the committee to consider highways objections favourably. Thank you.
Thank you, Councillor Strong. I believe you have to leave the room now. Thank you. Right, I now welcome other comments from other members of the committee. Councillor Powell first, please.
Thank you, Chairman. While I have great sympathy with the lady in the house next door, it should be that it could be policed. There are many, many, many businesses in all these towns on streets where there is no possibility of people parking by them, and people run the businesses from there, and their customers have to walk to it from some distance or other. There would be an odd time, I expect, when somebody is disabled that they could not come in any other way, but that would be very not very often. It doesn't mean that you can't run a business from somewhere where there's no parking. If you think of streets in every town in this county, you've got streets where there's no parking close by and they have to walk from a car park. So I think the main problem, which isn't a planning issue, is that it is policed either by the owner of the business or by the police themselves, the parking restrictions. The actual planning issue is whether we consider this to be fit to be an office. And I think that on that side I do support it.
Thank you, Councillor Powell. Councillor Harris?
Thank you, Madam Chair. Councillor Powell has said what I was going to say, particularly on the parking point of view of businesses. You go to Cross Street in Abergavenny, there's double yellow lines, and there is very limited parking space there. I think if this is to go ahead, it is absolutely incumbent upon the solicitors to establish anyone walking in through that door where the vehicle, their vehicle has been parked, and if it's in that drive, they must be told immediately to get the vehicle off the drive. Secondly, you can see the double yellow lines there, and they're just double yellow lines. Now, there are other enforcement procedures. There are no parking at any time possibilities, and we just had one in Abergavenny now. And it really is incumbent upon the police to actually enforce. We hear time and time again, you can put the yellow lines there, but we're not going to enforce them. And that makes a mockery of having yellow lines, to be perfectly honest. I can't see why we can't have no parking at any time along both sides of that road. It is very dangerous, that junction just to the right, and in actual fact, traffic coming in from the other direction. And I think it is incumbent upon, as I say, first of all, the business to make sure that nobody parks in that drive and does something about it if they do. And secondly, to consider no parking at any time on those double yellow lines on both sides of the road there. There is another business, I believe, just up the road to the left, so it can't be suddenly that this is a bolt out of the Blue business use. So on planning grounds, and bearing in mind the number of jobs that are coming there, I find it very difficult to say no to this, and it's up to, as I've already said, for the parking there to be policed absolutely properly. Thank you, Madam Chair.
Thank you, Councillor Harris. Councillor Alan Wintle.
Thank you, Madam Chair. Just really a question to Rob. I remember when I was in business, working from residential property, I was, well, it was not enforced, but I was told in no uncertain terms that I couldn't cause a nuisance and allow people coming into that property. Could you confirm that, Rob, please?
Yeah, I think that the principle is that if your home was your residence, your main residence, then it should be used as a main residence. And if, for example, it's used for the purposes of maybe an office, and there were people going back and forth there quite a while, then that would have an impact on your neighbours and your neighbours' reasonable enjoyment of their properties. So I think that's what you were advised at the time. And yes, that would still hold true, which is why we have a planning regime in Wales. So planning purposes, each building is allocated a planning purpose, so hopefully it doesn't conflict with neighbouring properties.
Thank you, Rob. So in that case, it's incumbent upon the solicitors not to cause a nuisance. And so while we would like the police to enforce the yellow lines, it's the people who are trying to run that business from there who must do the enforcement, I'm afraid. Thank you.
Thank you very much, Councillor Wintle. Councillor Jim Higginson.
Yes, thank you, Madam Chairman. I appreciate all all's been said in relation to, the reasons why it should be accepted. However, particularly in this county, we have a problem with a lack of residences for people to take up to live in. And for my part, I can't see myself supporting this application, because I think we're particularly in view of the fact we're talking about converting part of the building to office space. I think it is in essence, I believe, a flat in it, or what, you know, it's probably a flat. But I think that we need these types of properties to cater for certainly the number of people who want to live in the county. And the other, excuse me, and I noticed that the number of employees expected to start at 3 and rise to a maximum, but that's expected. Who knows it's going to be 7? Yeah, I mean that's something that is, you know, is it might be pie in the sky in the moment, I don't know, but it is expected. But and the comment has been made. There are empty premises or available premises within the Usk main shopping centre that could be used for solicitors' offices. And on that basis, I think that I couldn't support this application. In relation to the double yellow lines, and my late wife she was disabled, and anyone who's disabled can park on yellow lines, other than if there are yellow lines on the pavement at 90 degrees to the yellow lines that are there, and there are none there. And you know, if this application is accepted by the council, and I think that there should be some stipulation from the Highways Department take suitable measures to ensure that no one parks there. I mean, I have every sympathy with the people living at the top end of that lane, because inevitably, if it's only the mail van that calls in there, it's something that shouldn't happen. And I have every sympathy with the people living there, which is why, that's one reason. But the other one is I think we need to keep residences for residents and not for offices. Thank you, Madam Chairman.
Chair, can I?
Yes,
can I just,
thank you, Jim.
Come back on a point of that. The problem with this property, council, is that it has no garden. It has no garden curtilage, so its suitability as a large family dwelling is restricted there.
Councillor Murphy.
Yes, thank you, Chair. Can I ask a question of our officers a sec? Looking at the conditions here, and it says the premises should be used as solicitor's office and dwelling and for no other purpose. Now, I appreciate that the deeds for these properties only allow pedestrian access down that lane for that particular property. But would it be possible for the conditions to be expanded so that they say, and not to allow parking for any purpose or something like that? I just wondered whether it could be enforceable that the solicitors do actually make sure that nobody parks in that lane. But I'm not sure where the legal grounds are. In theory, they can't do it anyway because on the deeds it doesn't give them permission to do it.
They don't own.
Yeah,
they don't
perhaps
own that
Rob
passage.
or somebody can clarify that.
I'm not sure. Sorry. That was going to be my question. I'm not sure, Councillor Murphy, what the red outline is on the planning application. And
that's the lane, isn't it? Yeah. Yeah. So the lane is outside the red edge on the application.
So as the lane is outside the planning application site, then it wouldn't be possible to put a condition on there. The reason for that is that the applicants wouldn't be able to control what's going on over his or her land in that he or she doesn't own it.
Thank you, George. You wish to comment? Thank you.
Yes, Madam Chairman, just a comment. Listening to the way the debate's going, I'm just wondering whether, and I'm asking this sort of speculatively, a Section 106 agreement might be appropriate, whereby the solicitors actually fund the means of barriering the access way. There's no reason on earth, it seems to me, why the local resident should have to fund that. So if there is abuse, then I'd have thought a Section 106 agreement could be sought whereby the solicitors install, with the adjoining householders agreement, the necessary barrier to then prevent abuse of that element. So I'm just suggesting that, Madam Chairman, as a thought.
What will we do, George, when you leave the council, when you've got a wealth of useful information like that and proposal? I dare say that would be a good idea. I don't know what the planning officers think of that.
I mean, a good point. Section 106 agreement requires the agreement of the landowner as well. If that wasn't forthcoming, then the solicitors could, by unilateral undertaking, agree, and the council could insist on this as well, that if the landowner then endorsed having such a barrier, then the solicitor would then, or the firm would have to pay for it and install it. So I think that might be a way around it. But we can look at the details, Madam Chairman, if this is perhaps a way forward which assuages some of the understandable concerns from the local resident.
This is obviously
And
the sticking point because they've got pedestrian access, but it's the vehicles that are causing,
exactly, yeah,
causing
yeah.
the problems. Thank you. Anybody else wish to comment? Councillor Howard, you had your hand up, I'm sorry.
I think George is virtually going down the lines in what I was probably thinking about as well, because of section 106 on the double yellow lines which we've got there, a new traffic order going down Councillor Harris's issues, which we do have within Monmouthshire, is them yellow lines serve no purpose for unloading, whereas we've heard from the objector, the lady, the landowner next door, that actually people do pull up there, unload mails, etc. If there was a 106 agreement that the solicitors actually paid for a traffic order to enforce them yellow lines, and I think they are red etchings now, I'm led to believe. They are enforceable very strictly nowadays. Actually, I'm led to believe video evidence parking there or photographs will produce a summons. Them lines, for me, a compromise would be far better than going down a refusal, because I'm minded at the moment to actually not accept this, but I would accept this with some compromises on them lines. And I appreciate George's comments about actually putting some form of barrier there. Well, there is complications with the width with that. You probably gate access with the, I mean, but there are things which can actually make this application work for both parties if they're willing to come to some agreement. So I am minded, but I do believe that we can get somewhere with this one.
Thank you, Councillor. Councillor Dovey?
Thank you, Madam Chairman.
Thank you, Madam Chairman. What would I do without Councillor Wintle on my right-hand side here? When taking over the site, it must have been known that there would be planning issues as far as parking is concerned, because you know, the rights of way to the property behind. The person who took this on as a business must have known, if he had done his research properly, that there would be issues as far as parking is concerned. So that is down to him entirely. The other point is, if this is granted, there is no reason to believe that the present incumbents of the business might be there for the long term. They might be very responsible, you know, in terms of going out and saying you can't park there, you can't park there. It's very difficult to say to an elderly client, perhaps, that's come in and parked their car up there because they have difficulty in walking, you've got to move your car. I'm not going to do it. You know, that is a fact. That is a fact of life. And the other thing is, if they're not there in the long term, there's no guarantee that any new occupiers of that as a business are going to be as compliant as the present incumbents are saying they might be. So the situation is always that the residents at the back, their position is vulnerable. The double yellow lines are there for a reason. No parking, because parking there would be a traffic hazard. You know, we were there yesterday. The issue is that it would be all right, I guess, for people to come in and out of their residences as a home, because that is perfectly natural. But you are talking about a business here where people are coming in and out of. I mean, the owners, to me, have set up this business here before ensuring what the implications were as far as the access to that lane in parking was concerned. There are places in Usk where this business could be lodged. It is my view that the business is in the wrong place if they want access in and out of there, and I wouldn't be prepared to vote in favour of this.
Thank you, Councillor Dovey. Councillor Harris, again, did you wish to speak?
Yes.
Then I'll
Thank
take
you.
Councillor Edwards.
Thank you, Madam Chair. With regard to the Section 106 for a barrier, I think that's a brilliant idea. It could be a three-quarter barrier to allow pedestrian access, so that shouldn't be a problem. And if the barrier is supplied, it must be legally put into the ownership of the resident there that's having all the problems, i.e. solely controlled by that resident. The sister's business should not be able to control that barrier in any way, as far as I can see. If that barrier was installed as a three-quarter barrier and was in the control of the affected resident, and something sensible is done to the yellow lines to make it no stopping at any time, totally enforceable. And Councillor Howarth has mentioned that it may be possible for photographic evidence to start some legal proceedings. Then I would move that we could accept this application.
Chair, can I just say, there's a lot of talk about a barrier. I think in this case, we don't really need a barrier. A collapsible bollard may just suffice.
That's exactly what I'm listening. Councillor Edwards, and I'll take Councillor Dovey again afterwards. Well, before I take Councillor Dovey, I will take Councillor Webb that's been patiently waiting. Thank you.
Yeah, thank you, Chairman. Can I first of all go back to the remarks made by Councillor Powell, which was over the question of most properties in Great Britain do not have their own parking facilities. Every main street in the United Kingdom has or are unable to park immediately outside their own premises, and if you go to car parks. And this situation arises here. As I understand it from the application details, there has been some sort of business operating from these premises for the last 20 years. So on those grounds alone, you know, I think they have there has been created a precedent that it has been used for business purposes. As far as the yellow lines are concerned, I think we're trying to sort of crack a nut with a sledgehammer here, because the yellow lines as such, as they stand, forbid anybody to park there except a disabled person. And, you know, by putting the nibs on the edge of the pavement in right angles to that, then would forbid disabled person. So that would be, I think, going over the top, quite frankly. I think you've got enough evidence there with double yellow lines. A few phone calls to the police may well resolve it. But I think the ideal answer is probably, at the end of the day, is the Section 106, and I fully endorse what George has said, and now Paul has come up with the demountable bollard. Why not? You know, I think this would be an ideal situation, and on those grounds, I'm quite happy to support this application.
Thank you, Councillor Edwards. Councillor Anne Webb.
Yes, thank you, Madam Chairman. I would like to agree with Councillor Powell's words and also Paula's with regard to the future use of this premises, because it can't be used probably as a family house. It's a big premises. Okay, parking in all of our towns, as we've already been said, is inconvenient, and there's a short walk to the car park here, and I would like to second Councillor Powell's to accept the officer's recommendation.
Councillor Webb, I will now take Councillor Dovey. You had something quick to say?
Yes, Madam. There might have been, Madam Chair, there might have been a business there for some years, but perhaps the sort of business, and I don't know, that has been there didn't raise these sort of issues. These sort of issues are the ones that we're dealing with now. And as I see it is, yet we are here with some people who have a residence at the back, who've been living there quite calmly and being pretty good neighbours and all that sort of thing, and not doing anything wrong. And now they're right away, they have the problem of having to be out there if the weather's inclement, moving some sort of bollard or God knows what to get to their home. I think it's unreasonable. And I think the onus is being put on the people at the back in their home that have been living there without any problems at all, behaving entirely properly, and now they are the ones that are being inconvenienced. The fact of the matter is, I believe, and I'm sure it is an extremely good business, but it is, as far as I'm concerned, it is not right.
Thank you,
I
Councillor
cannot
Dovey.
vote for this.
Councillor Powell.
Just a quick one. There was concern about disabled people and people not able to get there. I would think that any solicitor worth his salt, if he had somebody in that position, would go to their home and visit them and do the business like that, because I'm sure they would do.
Thank you. Councillor Howarth.
Chairman, I need to be clear. Yes, I need to be clear with the double yellow lines with the red etchings on the curbs. Yellow lines are not enforceable for unloading and offloading, so where the lady made the comments about people delivering and parking up outside, i.e. delivering mail 5-10 minutes or whatever, you can't enforce that, and the police are very, they will not enforce that. You've got rights as people. I've got to go down the point there of the bollard, the red etchings, some 106 agreements. I could go along with this application, but at the moment we seem to be not getting nowhere with that. If a proposal's been made to more negotiation and discussions, I would support that as well. If that's a proposal you would like as members, that we withdraw this and if negotiations to be had, I would support it. But I still feel, going down Councillor Dovey's point, is people do have rights, and these rights are going to be infringed by bringing 6 to 7 people. And don't forget, if people are willing to live there, which has been stated in the application, whether they've got a garden or not, they're willing to live there, which has been stated in the application, so be it. And that's, I mean, if you want a garden, I don't take that as any material factor in this application. Whether it's got a garden or not, and it can't be used for domestic, that for me doesn't stand anything. So I would propose that this is withdrawn. If negotiations for a 106 agreement can be sought with our highways department and with the neighbour, I'd be quite happy to put that forward if I could have a seconder for that.
But you could say if it was a residential, if there was 10 people living in the house, where would they park, say, half a dozen cars? So
you only have to go into London. Yeah, I mean, but where do you park in London?
Yeah,
you
I
don't
don't
have any
think
parking.
it's really the issue of
No, it's
parking
not,
the cars on the road.
Well,
I think that's a highways issue.
Yes.
But also we are here to determine whether it is going to be for a mixed use, change of use to a mixed use. Is that correct, Councillor? So I think that's what the main reason that we are here debating it today.
But the officer did state that actually this lies 15 foot to 15 metres outside the class grade of what this practice should be. Was it 15?
Doesn't mean to say you can't have a commercial use outside the central shopping area. It
Okay.
just means that you have to look at it on its merits. Really.
Okay, that's what we're doing. Thank you.
Councillor Dovey, quickly, please. Then George can comment.
Been really interested to listen to all the comments. I must admit, when I was looking at it, whether it's a domestic dwelling or a business, parking is going to be a problem, like you were saying. Apparently, for that size, you should have 3 parking spaces. I have an issue very similar in Linishin, and at weekends they have huge problems. It's a domestic dwelling because people come to visit, family come to visit, and actually it's probably more of,
let's say, which the neighbours can then control and choose whether to erect it or not. So I was just making that.
8 for the application.
application and is at the Livestock Centre at Raglan.
Shrubs and grass to help screen the site when viewed from outside and to ensure that they are stable from neighbouring residential properties and act as buffers between the site and other properties.
We now go to agenda 5, and I believe, Phil, are you presenting this? Or Martin?
Renewable energy one, is it? Sorry?
Yeah, Martin. Right, thank you, Martin. I'm sure you can do it from there. Thank you.
Thank you, Chair. Yes, the report presents draft supplementary planning guidance, SPG, on local development plan policies relating to renewable energy and energy efficiency. It was prepared for the Council by consultants with a grant from the Welsh Government, and the team of consultants includes specialists in both planning and energy issues. The aim of the SPG is to help those making planning applications in these policy areas by providing further details and explanation of the relevant policies in the adopted LDP. In this respect, policy SD1 sets out criteria against which applications for renewable energy schemes will be assessed, but there are also a number of other policies that seek to encourage the optimisation of the use of renewable and low carbon energy in new developments in accordance with Welsh Government guidance and policies that promote the move towards zero carbon buildings. The SPG, therefore, is aimed, therefore, at a number of different audiences and scales of development, including new standalone renewable energy schemes like wind and solar power, but also households, small businesses and larger developments of developers of housing and mixed-use schemes, where there's a need to promote energy efficiency and the use of low carbon and zero energy. The first introductory chapter of the SPG in this respect includes 3 route maps, one for householders and owners of business premises, one for land developers, such as those developing larger housing schemes, and one for energy developers themselves. And there's these route maps and guide these 3 types of developers to the relevant parts of the SPG that relate to the proposal. First, the following 3 chapters cover energy issues, introducing the energy hierarchy and the way of carrying out energy demand assessments. Secondly, providing advice on reducing energy demand and improving energy efficiency. And then there's a chapter on various renewable and low carbon energy options available. These technology options are expanded upon in Appendix 9 of the SPG, which is Appendix B to this report, which provide a number of energy fact sheets setting out information on each of the main technologies. The next 2 chapters cover planning issues, advice on how to find out whether planning permission or other consents are required, and secondly, advice on the requirements of the planning process, and given the sorts of information that needs to be provided with the planning application, the process has to be gone through, and also giving guidance on the main issues that would be taken into account in assessing planning applications. Again, this is material that is expanded upon in the energy fact sheets for individual technologies. A final chapter outlines the benefit of community involvement in renewable energy schemes. In this respect, we've had some initial comments from the Cabinet members the Cabinet member responsible for the environment, and he would like some additional information provided to this section to include some paragraphs that encourage further the developers to carry out community engagement prior to submitting to their planning applications. There's an additional document attached as Appendix C to the report. This is prepared at a regional landscape level by landscape officers to provide guidance specifically on wind farm applications, setting out criteria on which a decision can be made as to whether a formal environmental impact assessment is required, and giving details of the information required for landscape visual impact assessments. We're treating this as an advice note. It's not strictly a SPG, but it is cross-referenced in the SPG. And if it is to be used in Monmouthshire, it would benefit from a local consultation to add weight to the consultations that have been taking place on a Wales-wide basis. The recommendation of the report, therefore, is that both documents are endorsed by Planning Committee with a view to issuing for consultation and to recommend to the Cabinet member accordingly. Any comments received as a result of the consultation will be reported back to Planning Committee prior to seeking formal adoption of a final version of the SPG.
Sorry. Thank you very much, Martin. I'm sure we'll have plenty of questions for you now. The first one from Councillor Taylor, please.
Thank you, Chair. Can I ask, will we have, during this process, a briefing session for members to really provide us with more detail? Because I must admit, I've read the documentation, but it is very detailed, and I can't pretend to understand the implications of everything that's contained in there, and I think it would be very beneficial for planning members to perhaps have some kind of session prior to a planning committee or whatever the chair can arrange with officers, because this is something which is, you know, consistently discussed, and it would be much more beneficial for members to have a better understanding of it. Although I am really pleased to hear that the cabinet member was keen to have particular emphasis on engagement and consultation prior to applications, particularly large-scale applications being submitted.
I think that's very advisable, that and things alter and need updating, and I think if we could have had something like a booklet that is bullet pointed to some of the things that we really should take on board when we have these two things to consider. But then, we'll have to see how that progresses. But it's a good, what I would call like a reference on the shelf that we can really, on particular renewables, really sort of look at, whether it's the turbines or the solar panels, that you can really sort of get your head around it a bit more. Anyway, Councillor Harris.
Thank you, Madam Chair. This is a truly monumental document, and I would hope it must have everything in there that we need. And I'm sure that applicants and objectors will be using this document to highlight either their for or against on any application that comes in. And I'm not sure. I think it would take weeks to have a comprehensive. Well, yeah, but I'm not quite sure what a briefing. A little bit of knowledge is maybe worse than knowing the whole thing. But I don't necessarily disagree. But it's, as far as I can see, it's all in here. And if it's not, it's probably hasn't been thought of yet. Thank you, Chair.
Councillor Murphy, then Councillor Blakeborough, then Councillor Webb. Thank you.
Yeah, thank you, Chair. I'm really picking up on the same theme. If I was an applicant, I'd be very pleased to have this for guidance, and I'm sure planning officers are keen to see that everything is set down, so they've got something concrete that they can judge applications by. I was sad enough to plough through the whole lot, and that only reinforced my opinion that, yeah, this is a very useful document indeed. But as others have said, I think some sort of guide for members, perhaps backed up by a seminar, just the simple salient points that really need to be understood thoroughly when we've got applications before us. So if some thought could be given to that in the not too distant future, that would be quite useful, I think.
Thank you, Councillor Murphy. Perhaps a Tuesday morning for a planning committee when most people are available. Anyway, Councillor Blakeborough, please.
Yes, again, a huge document, very interesting. Definitely good sort of information given the reasons for renewable energies, sustainable energies, good look at pros and cons of the different types of technology. So all of that really useful. I guess what I was looking for, because my headaches when I'm in planning is fundamentally, I absolutely agree in sustainable energy. I do believe that we need to invest more in that and increase that. I then get into issues when I have to make a decision of where these things are going, and it's that type of information as a planning member needs. And on one of them, for example, here on 1.111, renewable energy schemes will be permitted where, and there's a little list to be mindful of conservation areas, to be mindful of AONB. Those are the kind of things that I would find useful, because I've got to make a decision not on my gut, but on legislation and guidance. So I think as Francis Taylor, I personally would like some sort of a brief seminar to go into a little bit more detail, but then some summary specifically for us as a guideline, what to look out for and what kind of questions to ask when these come up, which they are increasingly coming up.
Thank you, Councillor Blakebrook. Councillor Webb?
And thank you very much. Yeah, hooray, hooray, we've got it at last, and that's really, really important for us all. And can I just thank Martin and his team, particularly for all the work and all this valuable information that we've got in front of us. But like the other members, I would really appreciate a briefing, a short briefing, or some pulling out the most important things that we have to look at as regards to a planning committee. Thank you very much indeed, all of you.
Thank you, Councillor Webb. Any more quick? Councillor Harris?
To come back in again, Chair, it's interesting, Councillor Blakeborough's looking at 1.111, and right from the very beginning, renewable energy schemes will be permitted where there are no unacceptable adverse. What does unacceptable mean? Yeah.
Yes, thank you. Anyone else? No. Councillor Dovey.
I think it was probably raised a little earlier on, but I think when we get somebody ask us a question about these issues, what we really do need, and if I'm repeating it, I'm sorry, what we do need is, if you like, a quick reference handbook that, that at least if we don't have, if it doesn't tell us the answer, at least it tells us where we need to look in the answer, with a few lines that can outline the issues, and then it enables you to react to your members' problems without sounding too thick or whatever. But it also gives you the opportunity for you to be rather more speedy in responding, rather than having to work your way through this thing.
Thank you, Councillor Jim Higginson.
Thank you, Madam Chairman. Yeah, there's plenty in there, isn't there? The comment I want to make is it is subject to review anyway, really on a pretty much constant basis. But I'm prepared to move the recommendation, Madam Chairman.
Thank you, thank you. Is that all right with you, Martin, the suggestion that we have perhaps a seminar or a briefing on if the members themselves, if there are particular issues that they wish to raise and debate then, rather than in the meeting this afternoon, so that they could digest it and know what to look out for? Is that possible with you, Martin, one day?
Yes, that would be fine. We can arrange to get the consultants back and perhaps prepare something ourselves in the meantime in terms of the summary and briefing document.
Right.
So perhaps if that could be arranged before we bring it back after the consultation has taken place.
Right, that would be great. Thank you very much indeed, Martin. It is a lot of work and it's a lot for everybody to take on board. Quickly, Councillor Blakebrook, because I'm going to ask if we approve.
Chair. I've got sort of two messages here. I'm reading here, we're going to endorse this, but you're saying we're going to accept it to go forward for consultation, and that's fine then, because
Right, I believe somebody moved for it to and Councillor Murphy seconded. Could I have a show of hands, please? Right. Thank you all very much for that. Thank you, Martin.
Tones. Reproduce tones.
Okay.
Reproduce tones.
Item 6 now on the agenda. Thank you, members.
So this is the response to the Planning Wales Bill, Positive Planning for a Better Future. I'm on page 207. And this item is a briefing on details of the Welsh Government's proposed changes to the planning system in Wales to enable members to respond to the consultation exercise, which is due in midway through this month. The bill is seeking powers for the Minister to enact through secondary legislation and policy matters including a pre-application procedure, applications to be determined by Welsh ministers, changes to development management functions, changes to enforcement appeals procedures, and changes to the town and village green legislation. So taking those in turn, in terms of pre-application procedure, the bill seeks powers to bring in regulations to require applicants on specified developments to undertake pre-application consultation. So it's a little bit to do with what we were talking about earlier in terms of renewable energy. At the moment, that's not mandatory unless it's to do with things like certain wind farm type developments. But the proposals within the bill would make this now mandatory for applications to undertake pre-application consultation with the community. And as part of this, the applicant would have to submit a pre-application consultation report with any planning application then later submitted. The positive planning consultation proposed that this would apply to major applications and developments of national significance, the latter of which I'll come on to later. But major applications are defined as, for instance, applications for 10 or more dwellings, applications involving 1,000 square metres of commercial floor space, etc. And, for instance, the school applications for the new secondary schools would be major development. But most of our housing sites, large housing sites, would be major proposals, and the solar developments, for instance, would have fallen into the major development category. And there will also be a requirement for planning authorities to offer a pre-application advice service, which is not presently mandatory, even though Monmouthshire does run one at the moment. The consultation has set out a number of proposals regarding how the new statutory pre-application advice service should be delivered in terms of written responses, meetings, personnel to be involved, and also seeks views on a nationally set charging schedule, which would clearly be different to the one set locally by many local authorities. Other changes, in addition, statutory consultees will be required, that is, they will have a statutory duty to provide timely, substantive responses to planning authorities when they're consulted. At the moment, they normally get 21 days to respond, but that their performance can be patchy, and some statutory consultees, take significantly longer than that to come back on planning applications, which can lead to delays in determining planning applications. In addition, there'll be a new tier of applications known as developments of national significance, which will be made to Welsh ministers instead of the local planning authority. And currently there's no definition, as these would be specified in regulations, but the Welsh Government predict that there would be no more than about 10 applications per annum throughout Wales, and these would be in line with the list contained in the document, consultation document, which proposes developments such as underground gas storage facilities, liquid natural gas facilities, airport-related development, harbour facilities, railways, dams, and you get the picture, very major infrastructure projects of a national significance. And planning authorities will still be expected to undertake a significant amount of work, including submitting a local impact report to Welsh ministers, and local authorities would be expected to deal with the subsequent work in terms of things like discharge of planning conditions if permission is granted. In terms of applications that are made directly to Welsh ministers, the bill is proposed to give the ministers power to publish conditions by which major applications, that's the 10 or more dwellings, etc., I referred to earlier, where they can be made directly to Welsh ministers instead of a planning authority, a local planning authority. One of the proposals is when the local planning authority is designated as a poorly performing local planning authority. The criteria to be used by Welsh ministers to define poor performance are not yet established, although it is anticipated that the criteria will include timeliness of decisions and quality of decision making. So we watch this space on that aspect. In terms of development management changes, The bill makes a number of changes to the procedures, including the removal of the legal requirement for a design and access statement to accompany applications for planning or listed building consent, changes to information placed on decision notices, a requirement for developers to notify the planning authority when work starts on the development, which would be useful, introduction of the right to appeal if the planning authority fails or to validate a planning application, and greater responsibility, as mentioned earlier, on statutory consultees to provide a timely and substantive response during the actual application process. And importantly for members here, the bill introduces powers for the Minister to issue regulations on the size and composition of a planning committee and on a national scheme of delegation. The proposal set out in the current consultation paper, and they set out that the size of planning committee would be a maximum of 11 members and a minimum of 11 members and a maximum of 21 members, but be made up by no more than 50% of the total number of authority members, or we fall comfortably within that range. Where wards have more than one elected member, only one should sit on the planning committee in order to allow the other member or some members to perform the representative role for local community interests. And a quorum would be introduced for decision making, and 50% of the committee is suggested. Well, we don't tend to have that problem in our authority. And there would also be no substitute members allowed. The Welsh Government considers that planning committees should not be concerned with small-scale, non-controversial development proposals, which can be more efficiently considered by officers under delegation arrangements. A committee's role would be to deliver the adopted development plan by making locally strategic planning decisions, by determining those applications that are identified as major development, that raise policy implications, such as where there are departures from the adopted plan, and where there is quantifiable community-wide interest in a development which goes beyond protecting the private interests of one person or a group of people against the activities of others. Again, they don't define what that group of or size of people would be. A national scheme of delegation is proposed, with committee considering applications such as departures from the development plan, applications involving an EIA, environmental impact assessment, applications where the local planning authority employee or council member has an interest in the application, applications where above a specified development threshold, possibly set as major development, and applications above a specified objection threshold. Again, it's suggested that 20 letters could be appropriate. In our response, we suggest that could be artificially high in a rural area, so we've suggested it's set at a lower level to reflect more the delegation arrangements we have for this committee. And application call-in applications would also be accommodated within the national scheme. And our response to that the questions on planning committees and delegation are set out on pages 225 to 229 of this agenda. One of the key changes is the Welsh Government considers there may be circumstances in future where it would be necessary to merge local planning authority functions in order to provide more efficient and resilient local planning services. And the Town and Country Planning Act 1990 provides Welsh ministers with powers to establish what's called a joint planning board as a local planning authority for two or more local authority areas. The current legislation is not considered to be fit for purpose, as it does not extend to the inclusion of all modern local planning functions, such as the preparation of a local development plan or the collection of the community infrastructure levy. So they intend, or the Welsh Government intend to provide an accompanying consultation paper to set out proposals to extend the powers for joint planning boards to include all modern local planning authority functions. The intentions of the consultation paper is that a joint planning board would be served by a single planning department, and that membership would be drawn on a proportionate basis linked to population. And the numbers of elected members which will comprise the board will be prescribed by the Welsh ministers through an order. And it is proposed that the Welsh ministers determine the number of decision-making members elected to the joint planning board, and the number should fall between, again, 11 and 21 as per their committee formula, in line with independent research. It will be the decision of individual local authorities to decide which local authority elected members would sit on a joint planning board, but the numbers of members elected from each contributing authority will be prescribed in order to ensure fairness, transparency and proportionality. And there's a formula set out on page 211 to indicate how they would reach that, that number of members on the joint planning board, but it is very much geared to population of respective authorities. And our response to that element of the consultation is set out on pages 229 to 230, where we query how that will work and impact on more rural authorities such as ourselves. In terms of enforcement and appeals, the provisions seek to prevent developers from repeatedly submitting applications or appeals where they've failed to obtain planning permission before, which would be a good thing, and only in exceptional circumstances would new matters be able to be raised during an appeal, which is a frustrating point for us to actually experience as officers, where an applicant will raise issues which might have actually resolved the application when they haven't raised or accepted that in the application process. They've raised it in the appeal process, which makes us look somewhat foolish after the event, and the appeal ends up getting approved or allowed, where we would have allowed that development had they raised or brought forward that information in the first instance. And the costs regime at appeal would also be applied to appeals dealt with by way of written representations, and currently these are limited to appeals dealt with by way of a hearing or a public inquiry. So drawing towards the end, there's a review of fees, an increase in application fee levels in the region of 15%, which is welcomed as they've not risen since 2009. There are other changes. One of the key suggestions is to provide a refund of the application fee to the applicant where an application remains undetermined after a period of time, suggested at 16 weeks from registration for a household development and 24 weeks for other types of development. And again, we've responded to that in the consultation paper. And to extend the scope of planning fees to other areas, including applications for discharge conditions, and to offer a standard charge for drafting of Section 106 legal agreements, which again we've commented on in the consultation response. And in terms of town and village greens, which I appreciate is a peripheral planning issue, changes proposed include prohibiting applications being made to register the land as a town or village green where the land in question has, in inverted commas, entered the planning system. That is, i.e. a planning application has been submitted relating to that land. We all know the difficulties from Merton Green, how lengthy and time-consuming that process can be. The next steps for the bill are set out on page 212 in terms of a timetable, and we seek members' views on the proposed consultation on these items. Thank you.
Thank you very much, Phil. You've had a lot of work to do, and I'm sure you've been doing some of that while you've moved house and celebrated Christmas and the New Year. So, and I think that's, we are all finding it rather difficult to take it all on board because of it coming in now at the beginning of the year. I'm sure several will wish to comment on things. Councillor Blakeborough first, please, and Councillor Webb. Thank you.
Right, no comment, but a question, really. I've glanced through this and the summary has been brilliant. I still need it distilled down to a few headlines, really. So as a member, I guess, my concern in drawing on your expertise and the length of time you've looked at this, I just need to know the changes in the bill, just some highlights that you've picked up. What are the benefits for Monmouthshire from this bill? What are the good bits that will help us? And then the second question is headlines. What changes in the bill have an adverse, or you could think could have an adverse effect on Monmouthshire, and anything that you want to highlight for us to, for concerns that we need to be mindful of. So the goods and the bads in a summary.
Okay. Yeah, there are several good things coming out of the bill in that they're looking to front load the planning system, which is always good, through pre-application device processes. I mean, ironically, we've already got that in place for Monmouthshire. Some authorities haven't, so it'll help them in a sense to come up to speed, catch up. for Monmouthshire, perhaps because I wouldn't say we're one step ahead. We're doing reasonably well in terms of the process we've got in place. A lot of this won't impact that much on us, but it will, as I say, help the authorities which haven't got such systems in place. There are going to be a lot of significant changes. A lot of that will challenge what systems we already have set in place. For instance, the pre-application process could have an adverse effect on our current processes, in that if, for instance, Welsh Government set the fee nationally, how realistic is that fee going to be set? We did a lot of work with the customers, working out what they wanted from our process, what level we should charge, what they were prepared to pay. Whereas if Welsh Government suddenly come along, like they do with the national planning application fees, and suddenly set a charge without having really done a great deal of asking customers what they want, they'll probably challenge me by saying they have, then it is difficult to see how that's helping the customers in Monmouthshire. So there's a lot of sort of worrisome things attached to this, to see how it all pans out. There are some good things that will have to consist of a minimum set of standard, provision of reform set by Welsh Government. There should be few appeals on that process, but we will get challenged on that. That's probably a good thing. It worries me that the Welsh Government are considering, instead of giving a carrot to local authorities to improve their performance, they're now giving us a stick to say, if you don't improve your performance, we'll take you right away to deal with applications at a local level. That is a worry, instead of actually providing resources and help to local authorities to actually improve their performance so they don't slip below the threshold where the local authority, the Welsh Government will step in and deal with things themselves. But we'll have to see again how that pans out, and how stringent they're going to be, and how quickly they're going to step in and provide that sanction. And planning committees, I don't think we've got a great deal to worry about there, because we already conform to much of what is suggested in the national scheme. The scheme of delegation, again, isn't that dissimilar to ours. As I said, that specified threshold of 20 different letters from different households was set a bit high, I think, for a rural area. So we've said that in our response, where we've said we set it at 5. Sorry, George. Yeah,
Thank you, Madam Chair. I'm just going to comment on a couple of things as well, if I may. That the outcome is obviously going to depend on how these sort of elements are actually implemented, because something like a joint planning board could be a good idea where two authorities are very similar. One's thinking about a national park in Pembrokeshire, for example, or Isle of Anglesey in Gwynedd, but it would be utterly inappropriate for Monmouthshire to combine with Newport or with Torvine or another authority where they're very different in character and the issues they have to deal with. And as I've commented before, that if and when the merger happens, for example, then I would anticipate that it would be in Newport's interest, if it was with Newport, as much as in Monmouthshire's interest, that there should be differentiation between the planning regimes in the rural area from the urban area. So, we would hope that either the joint planning board issue wouldn't be implemented in Monmouthshire's case, and that, as I say, if there is the merger happening through local government reorganisation, then sense prevails and there is differentiation. And the other element I'd comment on as well is the strategic planning panels, which is mentioned there, and strategic development plans. One of the issues here is that the Welsh Government, I think wrongly in my view, believes that by having a strategic plan across the region, then that will mean that local development plans for each authority will be that much easier, and by easier they mean less expensive, in which case the local planning authorities will then have to contribute money to fund the regional network. Well, that could adversely affect Monmouthshire's planning service. And in my very long experience on this with the old structured plan days, the fact that you had a structured plan setting strategic targets and so on made almost no difference at the local plan level, because it was the local plan level that all the arguments were fought through about the merits of particular sites and so on. So there's nothing cheap about the Monmouth Borough local plan process, despite the fact we had a structured plan. So again, it depends on to what extent financially we're penalised to help pay for regional levels, and so on and so forth. So a lot of this will depend entirely on how the Welsh Government actually implements the various processes they've set in train here. So we've tried to give you sort of diplomatic answers to the questions they've raised, raising these concerns, but not outright objecting at the moment, because we don't know so the extent to which the Welsh Government will actually follow some of these through.
Can I just quick?
Thank you, George.
Just to understand, because on the joint sort of planning board idea, so if you say had Newport, part of the merger, Newport and Monmouthshire together, you could have a planning board where, I don't know, 15 are from Newport, 10 are from Monmouth, goes out to voting. We're going to lose all the time, aren't we?
Well,
I'm assuming.
Yeah, but I think the case is the joint planning boards wouldn't apply if the merger has actually happened. And if the merger hasn't happened, then because we're very different planning authorities with very different issues facing us, one a city and one a very rural area with market towns, then I cannot possibly see how the Welsh Government could actually say it's appropriate to have a joint planning board in our circumstances.
Thank you. Councillor Webb?
Thank you, Madam Chairman. Thank you. Yes, I've enjoyed reading part of the document, and I'd be glad of any further information that we can gather. And also, there's a few new words in my dictionary. Allo word in. I'm being pedantic now. On 236. Yeah, on 236. Yeah, and turbineer. I like that word. It should be turbines. I think it's turbineer. That's nice. I like that. 238. 236. Scale including site area, the number of turbineer and the height. Turbineer.
I think Councillor Webb would like to be a spell. She would like to come and correct your spelling.
No, I wouldn't. I know the feeling, Phil. Sorry. What? I know it. I know, yeah. Okay. I know the feeling, so it's nice to get my own back. Thank you.
Just a couple, Madam Chair, following on from what Councillor Webb said. I mean, on page 235, question 4, we talk about spelling, and I just hoping that this is, I appreciate what Phil said. And on page 236, it must be our planning department on ALO allowed.
You've already said that, yeah.
But, the little things like that, and I hope this checked before. And there's another one somewhere about turbines, yeah. Question 11C, turbineer.
Thank you. If you could both shut your mics off, please. Councillor Harris?
So just another little bit of nitpicking. For example, on page 228, question 11, we've agreed something, but should it not be in the box, yes, subject to further comment, because there is a comment there, and the same on question 15. They're asked, if we say no, give a comment, and we haven't. 229, question 15. Specific reasons, etc. Yeah.
I'm sure Phil will go through this again anyway, so it'll be good. Right. Jim has proposed that we accept, seconded by Councillor Howarth. Could I have a show of hands, please? Right, we now go to the last item on the agenda, item 8. This is to consider the timing of future planning committee site inspections. Councillor Jim Higginson.
Thank you, Madam Chairman. I did put a letter in, and it's not reproduced here. If it is, I can't find it. But what it is basically is this: that our site visits, they start at breakfast at 7 o'clock in the morning. I do my dinner about 3 o'clock in the afternoon. But no, I mean, to go back to the serious matter, I think these site visits these site inspections could start earlier. I don't see the point of waiting around half an hour in the morning. We could all be on the bus, on the minibus, at 9 o'clock and get on with the business. And it gives the officers more time at the end of that process then to do what they need to do.
Well, the officers do have to do late correspondence then, and sometimes if we've had a lot of site visits, it can be quite detailed, as no two site visits are ever going to be the same, and you think you're going to be 10 minutes, it could turn out to be half an hour.
So I'm proposing it's 9 o'clock start.
Yes, and I'm sure that if we have a lot, we always tend to have a break, which is very beneficial socially as well as necessary. So Jim, you proposed that we turn to 9 o'clock start in the morning. Councillor Webb.
I second that proposal, please, Councillor.
Anybody else wish to comment?
Chairman.
Councillor Howarth.
Spent many minutes thinking about what Jim's just proposed. I don't have an agenda item for that issue. Is it an agenda item? Was it a supplementary sheet sent through?
It's actually on the...
All right, he hasn't come up on my... I can't accept a 9:30 start. It's impossible for myself to be there for 9 o'clock start, sorry, Chairman. It's impossible, absolutely impossible. I think I have children who have to attend college. I have issues to resolve in the morning. If you're retired, that's brilliant. I'm not retired.
Neither am I.
I have things to do. I thought a compromise of 9:30. Councillor Higginson's been on the planning committee for some months now. I thought we could have gone through the next 12 months. We had a good attendance yesterday at 9:30. I've been able to...
I think most people, if you're in it, it's nothing to do with being retired. I'm not retired. Sometimes I get very tired. But if you're in a job of work, you'd usually have to start your job of work by 9 o'clock, and you'd have had to have been there to park up and start at 9.
Chairman, I am speaking, and I haven't finished speaking. My job does start at 7 o'clock on a Monday, maybe 6:30 on a Monday morning to get here for 9-ish. I'll give you an example. I was running actually 30 seconds or 2 minutes late. You as a planning committee, I did inform a member that I would be 2 minutes late. You as a planning committee decided to leave bob on 9:30. At 2 minutes, I was crossing over us bridge, and you had left us bob on 9:30.
I was not present. I was not present.
Which I wasn't very happy with.
But I was not present, so don't say you.
No, you was a planning committee.
Yeah, well, not personally. I wasn't present.
Chairman, we have a diary which is set at 9:30. Constitutionally, that is set at 9:30. We've agreed that at full council. I thought we would have abided by the decision of council setting that diary at 9:30 for planning meetings. And if anybody's got a diary on them, if they can have a look to tell me whether that is exactly what it says within the diary. I think the constitution is quite clear. We may have to take this to full council if needed be to change that. So be it. We've got. Let me just work out now. We've probably got two more planning site meetings. 3. Is it actually a big problem to actually keep 9:30 and resolve this during our AGM during May? And I would propose that we stay as we are. If I do have a second, thank you.
I've got several hands up now. I'll first take Councillor Evans, Councillor Harris, and Councillor Powell. Thank you.
Yeah, thank you, Madam Chair. Councillor Oath is right. It is in the diary for 9:30. I think this is the time to discuss it, because you start doing the diaries for next year. But I don't think it's the time to discuss it in the AGM. It'll be too late. The diaries will be done. So I feel that Councillor Higginson put a proposal that we start at 9 o'clock. I'll second it. But obviously we have to finish this council year as it is in the diary.
Thank you. Who else wishes to speak now? Councillor Harris and Councillor Powell.
I agree. I think we have to carry on as we are. But if we care to look in the diary, it says 9:15. And it's here.
Yeah, council, it's only affecting the people on the planning committee. And I think if If it's affecting the people on planning committee should discuss it. And if the majority of the planning committee want to start at 9, we should start at 9. If it's inconvenient, well, change places with one of your other councillors.
Thank you. Councillor Watts, then Councillor Blakeborough.
Thank you, Chair. I think what we might have to consider is the minibus. If you go out too early, probably the minibus is being used for schools.
It's already booked separately anyway. So.
I think, to my mind, a role as a councillor is part-time. A lot of people do have other commitments, including work and childcare. I think if somebody has to get their children to school and really just requesting half an hour so they can then join in on the democratic process of going out to with planning and looking at really important. Just playing around with that, it is half. In fact, we're looking at 15 minutes because we've got 9:15 in there. We're looking at 15 minutes. For me, 15 minutes to ensure that everybody has the opportunity to do their job. I don't see what the issue is, really.
It's on the agenda for the April 14th of April planning. Oh yes, it's Easter. For the planning committee, the 14th of April should, I hope, give us enough time. I'm not quite sure when the diaries get printed. Does anyone know?
It's too late, I think. It's after the AGM, but they don't...
Oh, okay. All right, so we've got plenty of... In fact,
I don't think we can use childcare as a problem to getting some at 9 o'clock.
Can we...
I can drop one before and be in this office at 9 o'clock in the morning and go to nursery. Thank you.
Just want to make the point about the difference between council officers and members. Actually, the council operates an agile working policy, and different people do different things. But actually, I see a lot of officers dropping their children off to school and then coming in and working commensurate hours with that. Now, members are in the same situation as they were probably 20 years ago in terms of what they do and where they have to be. And whereas officers, the working practices of officers have probably changed beyond all recognition. I don't come to planning committee because I just can't get there. I just can't get there. And also, I have to work and drop my child, so don't come. I really don't see, I fully understand that, I'm sure everybody'd like to eat, but ultimately, I guess, it's about making compromises, isn't it? And to be reasonable. If someone's saying, well, look, I really can't come, but, Simon attends regularly, I think it's reasonable to bring a sandwich maybe, or to, make allowances for that. Otherwise, you're just excluding people for the pure sake of
There is the option
half an hour.
of catching up later if you want to in your own vehicle, as you do, Councillor Taylor, and you can, I believe, claim for your travelling expenses. It is just that it's far more beneficial for everybody to be on the minibus and so on. Councillor Dovey.
Thank you, Madam Chairman. This comes up time and time again. It really bores me silly. The fact of the matter is, we are supposed to be a pretty modern, swinging county. Where I just said it isn't, with all due respect, Chairman, what you can accommodate and manage and get out and do and all that sort of thing. It is the fact that we have, in the main here, a coterie of people that are really very interested in planning. That is the first priority. Definitely. And the first priority must be to have people who are interested in planning being on planning. And you can go to big companies, you can come in here at certain times. I really do think it's about time. I think for people in their various jobs, and we do have people that are employed other than retired. We do have people that are retired, and it is easier, who are professional people and still in work, but have signed up to and we're going to drive off. Councillor Clark said to me the other day that we nearly went, well, so be it, you know. A couple of times going without me would make me think.
Council diary. But I must admit, nothing. So I hope that a compromise can be general meeting, and it should really be a 30-second job, shouldn't it, in my opinion?
Discussion, everything. The real reason for starting early is because in order to get the
Madam Chairman, may I just finish off then? Yes, we've got 9:15. Anyway, Madam Chairman, I do welcome your input, Rob, and my memory has come back to me as reference to the AGM. Yes, 30 seconds, that should be all.
Thank you, Councillor Howarth. Councillor Clark?
There is a compromise here, isn't there? Something to look at, and we get back here at 2:30 in the afternoon. Now, I'm probably and go back to 9:30 on the short agendas. Let's have some common sense here. And that would be sensible. And if the officers work it backwards, and they do it every time because they put the times down for us, as long as we're back here between 1 and 2:30, that's fine. But I don't find 2:30 or 3 o'clock acceptable at all. And I think some common sense needs to be adjusted here.
Councillor Murphy?
Oh, something I hope is the final comment on this, because having heard Rob, I don't know why we're still considering this, because it's a total waste of time. But having said that, Peter makes a very valid point. The bit that he's omitted was the fact that on the last long trip, the minibus driver was panicking because he had to go and do a school run. And the longer it goes on, the more it impacts on other things. So I think Peter's right, but we can't discuss it until the AGM, so I really don't know why we are.
I'm thinking on my feet here now that if there are a lot of applications that require site visits, and most of them do because it's very beneficial for us to go out and see the sites, is that we have to call another quick meeting to have another site visits, but I don't know if that would be appropriate to, you know, if we got too many to go on the agenda on the Monday, the day before planning committee. But you know, generally we seem to cope with it. We need to sort of perhaps hurry up a little bit more when we are on site visits and not get distracted as well, which would help. But we do also have to consider the applicants, because they have to make arrangements to be there if necessary, or the agent, sorry, you know, and they have to take time out of their day or whatever, so they need notification. The officers need to notify them as well. So it's not just us, there's other people involved as well. So I think perhaps the best thing for this now is that we leave well alone now until we come to the general election, as Bob suggests. I don't know what that. Anyway, I think we'll draw a line under this now. And but before I close the meeting this afternoon, I'm sure most of you are aware that George is soon going to retire, and welcomed his massive knowledge on the county and policies and so on. Not necessarily always agree with what George says, but he always takes it pretty good on the chin when we do have to say. So we all do wish George all the best for your retirement.
Thank you very much. Thank you for the very, very kind words. I just want to say, yeah, I've been in courageous decisions you've had to take in the sort of face of huge opposition and so on. But despite that, it's always been a very good neighbour.